Hey everyone, welcome to the BU 231 midterm review session. What we're going to do today is we're going to walk through the details of what to expect on this exam. Then we're going to talk about study strategies, how to best prepare for the exam. Then we're going to talk about strategies in terms of how to answer questions so that you do really well on the exam as well. Lastly, we'll end by doing a topic by topic review of everything that's covered on the midterm exam. So starting with the exam itself, what you can expect is 7 short answer questions and 1 multiple choice question. In terms of what the exam itself will look like, we've provided you with multiple examples of previous actual midterm examinations. So what I have in front of you right now is the midterm exam from fall 2023, so about 2 years ago. And as you go through it, you'll see that the style of the examination, it's what we call a hypothetical examination. You're going to be given a lot of text and a story and a background as if a client had come to ask you and told you about what happened, right? And then you're going to be asked questions after a group of text is given to you, right? And so the way to approach this is to read the text above the question and then answer the question. Then the next bit of text will add a bit more details to what was previously told to you, continue the story. Then you'll be asked another question. Then you answer that one, and so forth, right? One little tip that's useful to know is sometimes it makes sense to just scroll down to the bolded question and read that first, and then go up and read everything else. That bolded question might give you some insight into the types of things you should be looking for in the text itself, right? And the idea here, just so you understand why it's set up this way, is to test whether or not you can take these unstructured facts and problems like you'll encounter in real life and be able to identify the right legal issue, analyze it, and then come to some conclusion one way or the other. And we'll get more into how to answer these types of questions in a second. So now we're going to focus on how to actually study for this exam and some good study strategies to make sure you succeed on the exam. So the first thing you should be doing is making sure that you're familiar with all of the content that has been covered in the course so far. We've provided you with a study sheet, and we've highlighted some of the most important things on there, and those most important things are the most likely to be examined on as well. So this is the review sheet that we've provided you with, outlining all of the topics that we have covered up until the midterm and everything that's examinable. As you scroll through this, you'll notice that some things are highlighted. Like for example, here, the idea of offer and acceptance and all their subpoints. Whereas some things are not highlighted, like jurisdiction of contract over here. And we tend to highlight the things that are the most important things for you to take out of this course. And these also tend to be the things that we want to examine you on, right? We want to make sure that you are, in fact, taking out the most important things from this course. So in terms of studying, you should prioritize those things that are highlighted. That will give you a good sense of what to expect on the midterm. After you've familiarized yourself with the contents of the course and everything that's on the study guide, I would then suggest that you go through and complete the assigned practice questions. You can then review those questions against the answer key that we've provided to you. You can find the practice problems by going to the My Learning Space page, and then you go to Content. You can look at the practice problems in each of the weeks, right? So for example, if I pull up weeks 2 and 3 here, we're going to see the learning objectives, the topics covered, and over here we're going to see optional practice problems. Chapter 4, case problem 2, right? I could do the same thing in week 4, and I'll see the same thing here. And these are specific problems that I've pulled out of the textbook that best exemplify the types of things that we are likely to examine you on because, again, they are the most important things we want you to take out of this course. In addition to that, we've provided an answer key. So if you scroll up here, you'll see it over here, chapter problem answer key, and you click that link and you click here. This will bring you to a document that has the answers that I've drafted to these problems. So what we would suggest you to do is to do the practice problem first, and then look at the answer after and critique your own answer. Now we're going to talk about how to actually answer questions on the midterm exam itself. There's 2 styles of questions. There's multiple choice and there's short answer questions. Multiple choice, fairly simple. Just circle the right answer on the actual exam page itself. That's all you need to do. You don't need to actually explain your answer, you're just choosing the right answer. There will only be one correct answer. So if you're struggling with these types of questions, just cross out the ones that are wrong in any way possible, and you should be left with only one correct answer at the end. Now, more difficult are the short answer questions. We've discussed this multiple times. You got a lot of feedback on your assignment as well about how to properly answer these styles of questions. But I'm going to re-review this just so it's top of mind too. So what we do to answer these short answer style questions is we use the IRAC method. So this stands for issue, rule, application, and conclusion. So the first thing you want to do is you want to set out the issue. The issue should be a single sentence that you're going to answer in your conclusion with another one or two sentences, right? So for example, is the defendant likely to be found liable in negligence? That's the issue, right? Your conclusion will be then, yes, they are likely, no, they are not likely, right? The next part is to outline the rule, right? In the rule section, you're not applying anything yet to the case. Instead, all you are doing is you are setting out the legal doctrine or the rule that applies to answer your question. So if we stick with the example, is the defendant liable in negligence? The rule would be to succeed in negligence, you must show 4 things. And then you're going to set out in detail the legal rule, including the definition of the duty of care and how to meet that test, how to set the standard of care and how to determine if it's breached, right? You're going to set out the 3 different types of damages, and then you're going to set out the test for causation, right? Here, you're not at all discussing the case, you're just putting what the legal rule is, okay? The next section is application. In the application section, this is where you go step by step through the rule that you just told me, and you apply it to the facts of the case. We'll talk about how to do this effectively so that you get full grades, but this is the standard structure that you should be following. Lastly, you conclude. Like I said, your conclusion should just simply answer the question. One question I often get about this structure is, where do I put the defenses? And we're going to go through how to effectively answer these styles of problems using this structure. But generally, there's 2 different types of ways that people think about defenses, right? One is what I'll call a counter argument. For example, the defendant may argue that there was no duty of care owed. That should go in the duty of care section in the application section when you're applying it, right? You would say, we argue there is a duty of care for these reasons. The defendant is likely to argue that there is not a duty of care for these reasons. This is what we think the likely outcome is. That's where you put it, right? If you're talking about positive defenses, so for example, if you're going to use the defense of consent to battery, right? That goes after you've done your analysis, right? So you finish your analysis for battery, has it met the test for battery? And then you say, here are the defenses, right? And whether or not you put the rule for the defenses there or you put it in the rule section is irrelevant. That's just a style choice that you can make. So how do you take this structure and answer things effectively and get a perfect grade, right? So the first thing is to identify the right legal issue. It's difficult to do because you're given this unstructured problem. So you have to take the facts and you need to be able to identify what the legal issue is. That's the first stage, right? Identifying the right legal issue. The next way to do really well is to properly explain the legal rule that will solve that issue, right? And so not making any mistakes in the way in which you analyze or you explain the rule that applies to the issue in the case. And then the big thing that differentiates a B answer from an A answer is the next part, is the application, right? So being able to take the issue and the rule that you've identified, that's a baseline, and now being able to fully apply it to the facts of the case. So what you want to do is you want to be able to explore all applicable counter arguments and defenses. So the way to effectively answer a question is to analyze it from your client's point of view, but also the other side's point of view, to anticipate any sort of arguments they're going to make and how you're going to diffuse those styles of arguments, right? The worst way to advocate is to put on blinders, right? And not address the other side's point of view, right? And so that's usually what differentiates the perfect grade or the A grade from a B grade, is the ability to think through the problem from both sides and address both sides of the argument. Lastly, you want to make sure that your conclusion is actually logically following from your argument. So for example, if you conclude that the standard of care was not breached, but in your conclusion you say that there is likely to be negligence, that does not logically follow, right? So you want to make sure that your conclusion is actually following from your analysis. Lastly, and this is difficult, is not going so far that you're what we call throwing everything at the wall. So you're raising things that are irrelevant, right, that don't apply at all, just to try and show me that you know what you're talking about, right? This is a fine line, but you only want to apply things that are actually applicable to the case at hand, right? If you think something's on the line, so for example, let's say you don't know if the defense of voluntary assumption of risk applies to the case. It's perfectly fine to just explain why you think it doesn't apply, if that's your conclusion, right? What we don't want to see, for example, is a case that is very clearly negligent, unintentional, and someone bringing up battery, which is intentional, right? That just doesn't apply at all to the case. So that's the difference there. And just to ease your mind a bit, what we don't care about is what side you choose. You can argue for the plaintiff, you can argue for the defendant, it doesn't matter. We also don't care what your conclusion is, right? They're going to be successful in a negligence case, they're not going to be successful, that's irrelevant. What we care about is being able to identify the issue and analyze it fully, right? There's always two sides to litigation, right? And both those sides can be very good and competent, right? And so we don't care which side you're choosing or which outcome you're going to conclude on, right? It's all about the identification and analysis. Lastly, this is often a concern for students because it's a closed book exam. We don't care about exact wording, right? And so you don't need to memorize the exact test, but say this with caution, you need to be able to actually accurately explain what the test is. If you could do that using your own words, that's great, right? Again, we don't care about being able to mimic the exact words. It's about being able to convey the meaning, right, from the tests and from the rules. That's what matters. Now, in addition to those substantive points, I have some other kind of tips for how to properly approach these types of exams. So my first tip is to consider outlining your answer first on the exam paper itself before you actually write it out. This often helps you think through the problem. So by outlining, I mean, let's say, for example, it was a negligence question, and you just want to make sure that you have the right test for negligence out on the paper, and you want to start thinking through what your counter arguments are going to be and any potential defenses, is to, again, on a scrap piece of paper or on the back of the exam paper itself, just write out the four-part test of negligence, and then under, let's say, with a counter argument on standard of care, outline the facts that you're going to use to make that counter argument, right? And so when you're writing the exam, you could do this for each question one by one. That way you've gone through the whole exam, you have your answer outlined, you can do it pretty quickly, and then you're not so much worried about making sure you remember everything and what you're going to argue. You've already done all that hard work. Then you spend the rest of the exam taking your outline, putting it into full sentences, and as we'll talk about, writing it in an easy to understand and congest fashion, right? So on that point, when you're writing out your answer, what you don't want to do is have no paragraphs and multiple pages of just text from margin to margin, right? That's not just for us as the markers, that it makes it hard to read, but also for you. Your answer, if it's more structured, right? If you use headings, heading for issue, heading for rule, heading for application, heading for conclusion, and then you use separate paragraphs for each part of the test, right? So you have a paragraph for standard of care, you could even put a subheading there if you want, right? And then another for damages, right? And you go through the test. That is going to be a much more effective way to communicate your answer. It's also going to make sure that you do not miss anything, right? and that it is very clear that what you are talking about is related to that part of the test under which it's found, right? Um, what happens when students tend to write without paragraphs, without structure, is ideas are melding together, and it's very difficult for the reader to understand why you're bringing up particular things, what it relates to, if you understand the test at all, right? And that's often why students end up doing poorly on the midterm or on the final exam in this course. It's not about making things look pretty or aesthetics, right? It's about making sure that you're actually conveying the proper meaning, right? And so use paragraphs, use headings, make it as easy as possible to read. That's going to make sure you're conveying a simple and easy to understand message to the grader, right? You can use lists, of course, but use them for listing things, right? And so on the assignment, there were multiple groups that used lists for things that were not lists, such as paragraph numbers, and putting paragraphs and subparagraphs together in a list, right? That's not the purpose of a list. A list is there to list an item of things, right? So if you're listing an item, let's say the 4-part test, can I mention this again? You can certainly put that in a list, right? But don't do bullet point answers. Use a list as a tool. Now we're going to do a rapid fire review of everything that we've covered up to now in this course and everything that could possibly be on the midterm exam. These highlights and this list corresponds directly with what was already provided to you in the list that we referenced earlier. So if you recall, we started the course by talking about strict liability torts. These are torts where we don't care about fault, right? It's if you do the action, you are liable. Within there, we talked about two main types of torts, public nuisance, private nuisance, the difference between those being whether they relate to public land or private land. We also talked about the strict liability tort itself. This is when you have something inherently dangerous on your property that escapes and causes injury to someone else. We then moved to intentional torts. We talked about assault and battery. Remember, the difference here is assault is the threatening of imminent physical bodily harm against a person or an identifiable group, whereas battery is the actual touching of someone without their consent. We then talked about trespass, which is going onto someone's property without their consent. And then we moved on to intentional infliction of mental distress. And recall that this tort is an understanding of the fact that assault is very narrow. It requires imminence. It requires a threat of physical bodily harm against a group or an identifiable group. And yet there are some instances where people say things that are so flagrant and outrageous that they are known to cause actual harm to someone, right? And so intentional infliction of mental distress applies when there is flagrant and outrageous conduct, right, that in fact causes a medically recognized mental illness to someone else. We then talked about false imprisonment, which is the total confinement of someone without their consent and without lawful excuse. Then malicious prosecution, which occurs when someone commences a legal proceeding, which is broadly defined. And that proceeding, that criminal proceeding, it's terminated in the favor of the plaintiff, right? And so the third part is that the defendant who commenced these proceedings, right, they did so maliciously, right, and knowing that what they were saying was false, and they didn't have a reasonable belief for what they said, right? So very narrow circumstances under which this applies, but it is used in those instances where someone is trying to abuse the criminal process to cause harm to someone. Right? And then lastly, we talked about defamation. Recall, defamation is a very easy tort to succeed. Most of this has to do with the defenses. Although the defenses aren't delineated and highlighted here, these are included in this highlighting of defamation, right? And so to succeed in defamation, you need to show that something was said about the plaintiff, that identifies the plaintiff, right? That it was said to at least one other person, said or stated, right? And that a reasonable person would tend to lower the reputation of the plaintiff given the statements that were made. Right? So that's the three-part test. Most of defamation is decided on the defenses. We talked about numerous defenses. We talked about the defense of qualified and absolute privilege. which protects speech that is compelled, things like MPs speaking in Parliament, things like witnesses speaking at trial who are compelled to speak. We then talked about the defense of truth, right? If the defendant can prove that what they said was true, that is a full defense to defamation. And then we also talked about the defense of responsible communication on matters of public interest, right? Recall this comes from journalism, but it applies to everyone. And it is more concerned about whether or not the speaker or the writer of the alleged defamatory statement, whether they took the right processes to try and confirm the truth of what they were saying, right? So they don't have to prove truth, they just have to confirm that they acted in a responsible manner. We then talked about the defenses to intentional torts. So we have the defense of consent, right? If the plaintiff consented to the conduct, then that is a full defense to any intentional tort. We then talked about self-defense. Self-defense allows a person to use reasonable force when they have a reasonable apprehension of harm. Right? We then talked about necessity. You had no other choice but to commit the tort. Involuntariness, that's when your body does something that you didn't voluntarily intend to do. And then incapacity is when your brain is not capable of forming intent, right? We then moved on to unintentional torts. The big one here, negligence, right? We went through the test for duty of care, and remember, duty of care is concerned with whether or not the defendant owed a duty to the plaintiff, not the contents of the duty, right? So I noticed in marking the assignments, many people confuse these two things, right? Duty of care is just, does the defendant owe a duty to the plaintiff to take care? We don't care about what they should have done. We just care about whether or not they had to do anything at all, right? And this, again, I know I've said this numerous times, comes from the idea that you don't owe duties to everyone, right? So again, if someone is dying on the street, legally, you don't have a duty to help them. Morally, yes. Legally, no, right? And so what we're trying to figure out from the duty of care test is, at what point do you owe someone a duty, right? And this test is concerned with the proximity between the parties and whether or not that closeness creates foreseeability that if the defendant does something that is careless, again, we don't care about the specifics of the case yet, something that is careless, that that could potentially cause harm to someone like the plaintiff. After you've established that a duty does exist, right, you then need to talk about whether or not the defendant met the standard of care. We set the standard of that of a reasonable ordinary person. Unless they are a professional, then it's that of a reasonable profession in the same position, or a child, which would be that of a reasonable child of the same age in that position. We then compare that standard to the defendant's conduct, and we say whether or not they met it or not. Next, we talk about damages. There's three types: pecuniary or special damages, those are out-of-pocket losses; general damages, these are things that aren't quantifiable, like pain and suffering; and then punitive damages, which are awarded only in the most egregious of cases. Lastly, you need to connect those damages to the breach of the standard of care. To do that, we use causation. The test for causation is the but-for test. But for the breach of the standard of care, would the damages still have happened? If the damages still would have happened, there is no causation. If they wouldn't have happened, then there is. We talked about professional negligence, where we heighten the standard for professionals. Then we talked about product liability, which again, is just negligence, right? But we're applying it to products and trying to figure out who is liable for what. We talked about the Occupiers Liability Act. This tells us that all occupiers of land owe a duty to anyone who comes onto that land. And then it sets the standard of care for people who are invited on the land, expressly or implicitly, right? Sets that standard at having to take positive steps to ensure that the property is safe, right? Whereas for trespassers, people who are not invited, right, the standard is simply to not deliberately cause them harm, right? Which simply means you can't set traps. We then talked about the defenses to negligence. There's two. The two defenses to negligence are the contributory negligence defense, which is a partial defense, meaning you can't get liability to zero, right? Instead, the court's going to apportion liability amongst the plaintiff and the defendant. And contributory negligence is concerned with whether or not the plaintiff, the person suing, contributed in some way to their harm, either by increasing the likelihood that harm would happen, themselves creating or themselves being negligent, right, and creating part of the harm themselves, or failing to take steps after they're harmed to alleviate the injuries or the damages, right? So in all of those instances, part of the fault or the blame might be placed on the plaintiff themselves, lowering the damages that the defendant is responsible for. We then talked about voluntary assumption of risk, which is a full defense, right? And this defense very narrowly applies to circumstances where the plaintiff takes on activities that are risky. They are told about the risks of those activities, and then those risks in fact materialize. Students often confuse this and just think if the plaintiff does something dangerous, right, voluntary assumption of risk applies. That's not how it works, right? A good example is, let's say you were to go to a theme park, right? And on the outside of the theme park, there's a warning sign that says, this ride causes nausea. Okay? You see it, right? Yet you go on the ride anyways, and you get sick. Right? You can't now sue the company in negligence. Right? The idea is you were told about the risk, you took the risk materialized, right? And so despite that theme park company causing you harm unintentionally, they're not going to be liable for it, right? Because you voluntarily assume that risk. And this is a full defense. We then talked about fiduciary duties. Fiduciary duties are those special relationships between parties where there's someone in a position of power exercising control unilaterally over the property or personal decisions of another person. Right? That's how we establish a fiduciary duty. If that exists, then the fiduciary must place the beneficiary's interests ahead of their own interests, right? And they can't themselves act in any form of conflict of interest. In this context, we talked about the corporate opportunity doctrine, but this is something we'll revisit in the second half of the course. You don't have to worry about it too much for the midterm. Next, we talked about misrepresentation. Misrepresentations occur when someone makes a statement, the defendant makes a statement that the plaintiff reasonably relies on to their detriment, right? And this can happen in multiple ways. We focused on two. Negligent, that's when the defendant owes the plaintiff a duty of care and they fall below the standard in making their statement, right? And fraudulent, that is when the defendant makes a statement that is knowingly false, right? In both instances, the statements have to be false, and the only difference is that the defendant know it to be false and therefore fraudulently misled the plaintiff, or did the defendant not care and was reckless as to whether or not what they were saying was false, in which case it's negligent. We then talked about the damages, right, to all torts, which I've already walked through when I went through damages and negligence. It's the same analysis, the three different types. We then talked about other business-related torts. Two of them require three parties, which is inducing breach of contract. That's when the third party knows about a contract, creates incentives or inducements for a party to breach it. That party now becomes liable for that breach. Right? We then talked about unlawful interference of economic relations. That's when the defendant does something unlawful or illegal or commits a tort against a third party or someone else, right? Not directly at the plaintiff, and yet those harms cause injuries to the plaintiff, right? So the idea is, again, you need three parties more than the two parties involved. We didn't talk about product defamation due to time, so don't worry about it. We then talked about passing off, which is the common law tort of trademark infringement. We talked about some other concepts. Burden of proof, that's who has to prove what. Basics here, the plaintiff needs to prove their case, the defendant needs to prove their defenses. We talked about the fact that most cases are proven on circumstantial evidence. And then lastly, we talked about vicarious liability. This is when all employers are automatically liable for the torts of their employees committed in the normal course of business. We then moved into contracts. The first topic we talked about was contract formation. Right? So remember, there's three main requirements for contract formation: offer, acceptance, and consideration. The other four have to be there as well, but you don't really need to mention them in your analysis unless there's an actual issue, right? So the issues of intention to create legal relationships, the issues of capacity, legality, and the certainty of terms, those might come up. You don't have to mention them unless they're a problem in the case. We then talked about equitable estoppel. Recall, this can only be used as a shield, and what you are arguing is that the other party is stopped from raising an argument, and that's because the parties were already in a contract. One of the parties made a promise without consideration, right? And the other party reasonably relied on it, and it would now be unfair for the parties to go back on that position. We then talked about rescission, repudiation, rectification. Rescission is when the court will set aside a contract and place the parties in the position they were before the contract was formed. Repudiation is a breach of contract, which we'll talk about after the midterm, so don't worry about that. And then rectification, which is a remedy where the court goes into the contract, right, and they change it to reflect what the parties actually agreed to. That then brought us into circumstances where the court might rescind or rectify the contract depending on the circumstances. We talked about four ways in which this can happen. The first is a mistake. Many types of mistakes you see here. As I discussed in class, you don't have to identify the exact type of mistake. The purpose of setting these all out for you was to show you the many different ways in which a mistake can arise. The second we talked about was misrepresentation. And recall that misrepresentation is the same as the tort of misrepresentation, except used in the contractual world. And the way in which it comes up is when the other party to the contract misrepresents something to you before you sign the contract, and it induced you to enter it. And so you're using it as a way to get out of the agreement. We then talked about undue influence and unconscionability. This is instances in which there's a power imbalance between the party and that's being abused. And this can result either from a special relationship, like a prenuptial agreement before someone gets married. This can be due to the age difference between the parties or the power differences between the parties. So we talked about the Uber case and Heller, who was a driver for Uber, trying to sue them. And so it could be circumstantial, it could be relationship-based. In those circumstances, the courts are very unlikely to enforce contractual terms that are unfair. Lastly, we talked about duress. Duress occurs, this is the kind of situation where someone is using a threat to force someone to sign a contract. Then the last thing we talked about, actually before that, I see that I missed applied terms under the Sale of Goods Act. So just recall that these are terms in the Sale of Goods Act that apply to every contract unless the parties had agreed to exclude those explicitly. These are terms such as if you buy goods by description, like buying goods from Amazon, that the goods you receive will actually match their description on the website or their pictures, right? This includes the fact that goods you buy will be of merchantable quality. That doesn't mean they're perfect, it just means that they're of a quality we expect in that market. Lastly, we talked about contracts that need to be in writing. So recall the basic assumption is that contracts don't have to be in writing. They could be informal, right? Except in some instances they have to be. So we talked about a few of these. The key one, just to remind you, is contracts related to land, right? And so contracts concerning land, the renting, the buying of any land must be in writing. If they're not, they're unenforceable. It means the contract exists, but the court won't enforce it, right? We then talked about this doctrine of part performance, right? And the idea is if you have a contract concerning land that's not in writing, but the purchaser or the tenant does something to that land before the contract is performed that is inextricably linked to that land, like renovating it, like taking care of the land, then that will provide enough evidence that this contract exists that the court will enforce it. We then ended by talking about a few laws that require certain things to be in writing as well. So the Sale of Goods Act and the Consumer Protection Act, which generally say that contracts over $50 have to be in writing, and direct sales contracts, door-to-door sales contracts, also have to be in writing. I just wanted to end by wishing you all good luck, and I hope you have a really good reading week. If you have any questions, I've opened up a discussion forum on my learning space. You could ask your questions there. I'll be checking it once a day, and I will be replying to everything there. That way everyone has the benefit of all the answers. If you want any office hours, just email me and let me know. I'm happy to meet with you. So good luck. Enjoy reading week.